Hi, my friends. Here are Stefan and Michael. And now we have coffee at the airport in Jakarta.
Yeah.
We are very tired, because yesterday we had the production of coffee in Bali. So that was really exhausting.
Two movies.
Two movies. Yeah.
Just for you.
Just for the friends and for all the people in the community who wants to understand what's going on in intellectual property rights. And for me, it's a pleasure to ask my best friend and brother, Steve, what is his opinion? Because it's discussed really intensively in Germany, especially at the moment, whether data could be a subject of intellectual property, or is it just a right of human dignity, of personal right? So, Steve, what is your opinion?
Well, it is both actually. So it is of course based on the personality of the individual, and so it's also part of the human dignity. But more and more we see that personal data are a good which is subject to business, and so we cannot deny that there is a commercialization of personal data. So it can be that we need to add the data protection law with the data property law. So yes, actually there is a tendency to understand personal data as intellectual property of the individual, and therefore we need maybe more models to handle that. Very comparable to the copyright law. My best friend and brother Michael here is a professor for copyright law, so I think it's actually very similar, right? This connection to the personality.
Yeah, but you have something special in copyright law. You have that creativity you need. I mean, personal data are data you produce all around the clock. I mean, at the moment you produce the data that you're at the Starbucks in Jakarta, or Starbucks as they call it
Yeah,
here.
very true.
So it's really difficult to find the limits of such a right.
Well, actually, the difference is this is true, but the purpose of definition of personal data as an intellectual property right is a little bit different than the purpose of the copyright. The purpose of the copyright is first of all the purpose to protect the creator from a misuse or from a use against the will of the creator, and then second also for making the good with the intellectual property he created also subject to business to sell it. The data of the personal data of the individual is not actually directly sellable by the individual. So it is more or less let's say an helping construction to give more effective protection to the individual. It's more or less an answer to the phenomenon in the modern in the modern information society, that the individual is used for producing data, and these produced data are moved around the business and are given to other purposes. So it's a more let's say 90% it's actually a protection purpose, not so much the purpose to make it commercialable for the individual, right? Or what do you think about that?
I think it's difficult to say, but no, but you must say that's true, as you said before, that in a sense it has a core issue, which is commercial.
That's true.
Because when you are not allowed to commercialize it, then others are doing so, and they are already doing it.
But,
I mean,
but,
this
but
is the business.
compared to the copyright law, the copyright, I mean, if you write a book, for example, or you produce a photo, you can sell this as the creator directly to the market. Sometimes you need an editorial to make it more effective, but you can sell it. The individual data, the personal data, actually this personal data is useless in the hand of the individual. For that you need, for example, the platform or the processor, or Amazon or Google or Facebook for make this data the product. I mean, what the individual raised from his use of iPhones or of Google devices and of Internet of Things is raw material, he cannot sell it himself because he has not the access to the market for the data. Right?
So probably it is more a question of tort law when you see what are the compensation for it. It is not only compensation for the hurt of your personality, but it is also a commercial
That is very true. That is very true, actually.
infringement. So
Yeah.
that means that the number or the sum you get under tort law could become higher than it is now.
Well, it's true, and we have
Probably.
something comparable actually already in the personality right. In the personality right, we have the use of the tort law to use the tort law in a more preventive way to prevent media companies from infringing the personality, for example, of celebrities, which is not only compensation, which is actually more than the
Yeah.
compensation, is going to the prevention. And something very similar could happen to the personal data, with the contrary that in the celebrity law, in this personality law of celebrities, we are not yet in this development that we accept it full as movable intellectual property. We have this in the beginning in the Marlene Dietrich,
decision.
but only in another way. And here the courts say this is only for protecting, not for making a valuable good, because there's always this mistrust to commercialize too much, right?
That's true.
So here is actually we have a, maybe this is interesting to compare it in another movie later. So I
Yes.
think for now we are ready with our discussion. We need our coffee now. yeah.
Enjoy.
So Michael, we go to Medan now.
Yeah,
and then to
you know.
Amsterdam, right? And then
Somewhere
to Düsseldorf,
else.
somewhere. Yeah.
Bye,
So see you
bye.
next time in coffee
Enjoy.
in wherever.
Whatever.